Hi, I'm Barbara McGinnis with Takis McGinnis Elder Care Law. Today we're going to talk about joint ownership and potential pitfalls. Many people believe that owning property jointly with right of survivorship is an effective substitute for a will. The benefit of holding property as joint tenants with rights of survivorship is that such property passes to the surviving joint tenant on the death of the first joint tenant without going through probate. If you arrange your affairs to bypass probate, you save time and money as well as keeping your affairs private. Many times a single person will consider having a child assist in the management of his or her property by naming such child as a joint owner of the property. Such an arrangement has perhaps unintended consequences and even several disadvantages. For example, on bank accounts, the child could use the funds for their own benefit, thereby reducing or eliminating the parent's funds. The child could experience financial difficulties, and the funds in the joint account could be reached by the child's creditors. If there's more than one child, and the parent does not add all of the children to the account as joint owners, upon the parent's death, all of the funds in the account will pass solely to the child or children named as joint owners of the account, and the parent's other children will receive nothing from the account. If the parents want to treat his or her children equally, other arrangements will need to be made with the parent's other assets to ensure that all of the parent's assets will be divided equally among the children at the parent's death. If the parent has multiple children, who in turn have children of their own, and the parent adds all of the children to the account as joint owners, then upon the parent's death, all of the funds in that account will pass only to his or her surviving children, thereby unintentionally disinheriting the grandchildren, who are the children of any child who's predeceased the parent. If the parent wants a predeceased child's share to pass to that child's children, who are the parent's grandchildren, then other arrangements will need to be made with the parent's other assets to ensure that all of the parent's assets will be divided equally among his or her children, with a predeceased child's share passing to that child's children. If a parent retitles the family home or other real estate in joint names with all of his or her children, the following are some of the potential unintended consequences. The parent may not sell the property without all of the children and the children's spouses signing the deed conveying the property. The parent may not refinance any existing mortgage on the property or otherwise establish a home equity line of credit without all of the children and the children's spouses signing the mortgage or home equity line of credit. If a child who wants to cash in on his or her share of the property has the right to do so and may bring a lawsuit to partition the property. If a child were to run into financial difficulties, that child's share of the property may be subject to the claims of creditors. There are even potential tax consequences. If a person transfers property by retitling it in joint names, the transfer may result in a gift, and then depending on the value of the gift, it may be a reportable tax gift. For example, if the real estate is sold at a gain, that gain will be allocated equally among the parent and his or her children, who are listed as joint owners. Moreover, the child may be liable for some income tax on their own share of the gain because of the income tax exclusion for gain on the sale of a principal residence may not be available to that child. While creating joint ownership with respect to one's property is simple and inexpensive, it has potential traps, pitfalls, and risks. Suffice it to say that a single person who wants to avoid probate should carefully consider the consequences of adding a joint owner to his or her property before doing so. There are several ways to avoid probate. There may be other valid reasons to own property jointly with right of survivorship, but you just should discuss all of your options with your estate planning attorney before proceeding.